Blake Lively makes some serious requests to continue sealing documents. What's she afraid of? And is Sony finally turning against them?
Blake Lively just filed a new motion to seal even more court documents. After already hiding hundreds of exhibits from public view, she's back, demanding that critical communications stay buried. What exactly is she so desperate to keep hidden? And why is Sony Pictures now pushing back harder than ever before? Before we dive in, if you're interested in celebrity legal battles that go deeper than the headlines, hit that subscribe button and turn on notifications. This story has more layers than most people realize, and you're going to want to follow where it leads. Here's what makes this situation particularly revealing. Lively isn't just asking to protect a few email addresses or phone numbers. She's requesting that 940 exhibits remain sealed, including communications with her husband Ryan Reynolds, details about financial arrangements, and conversations with third parties who allegedly have minimal connection to the film at the center of this lawsuit. That's not standard legal privacy protection. That's a coordinated effort to control the narrative by controlling what the public can see. Let that sink in for a moment. The American court system was built on transparency. Federal civil cases are public by constitutional design. The First Amendment guarantees citizens the right to access what happens in their courts, to understand how justice is administered, to hold the system accountable. When you file a lawsuit or get sued, you accept that your case becomes part of the public record. That's the trade-off. You get access to the legal system, and the public gets access to the truth. Blake Lively wants a different arrangement. She wants the power of the courts, without the scrutiny that comes with it. And the question you should be asking yourself is this: if the facts support her claims, why does so much evidence need to stay in the shadows? Now pause here for a second. If this were really about protecting free speech, why introduce an argument that limits it instead? If that logic makes sense to you so far, hit like and subscribe, because this case only gets more complicated from here. Her legal team frames the sealing request around protecting non-parties, people who aren't plaintiffs or defendants, but whose information appears in the case file. They cite someone's medical records, contract negotiations, and communications that could pose security risks if released. On the surface, that sounds reasonable. Protect innocent bystanders. Shield private details that have no bearing on the actual legal issues. But look closer at what they're actually requesting. Ryan Reynolds was initially part of this case. He's since been dismissed. According to Lively's attorneys, that makes him a non-party now, which means his communications should be sealed to protect his privacy. But those communications don't exist in a vacuum. If Reynolds was discussing the very people and events at the heart of this lawsuit, if his messages with talent agents at William Morris Endeavor reference the defendant or the alleged misconduct Lively claims happened, then those aren't private family matters. They're evidence. And evidence belongs in the public record. The filing mentions potential security risks tied to family information. It suggests that releasing certain communications could endanger the Reynolds family. But here's where the argument falls apart. The motion provides no analysis, no concrete examples, just vague assertions. It doesn't explain what specific information creates a risk or why that information would have been shared in a professional email with a talent agent in the first place. It's a conclusion presented as fact, with no supporting logic underneath. Think about this. If you're discussing a business dispute with your agent, why would you include details about where your children go to school? Why would you embed security-sensitive family data in correspondence about a legal strategy? The claim doesn't hold up under scrutiny unless you assume that Lively's team believes the rules simply don't apply to her. And then there's the language in the motion that really exposes the strategy. Lively seeks to shield disclosure of names and identifying information of third parties with whom she has communicated, people who have not been subject to discovery in this action or have little connection with the film. Read that again. She wants to seal communications with individuals who have minimal involvement in the case itself. This isn't about protecting innocent people caught in legal crossfire. This is about burying conversations that might reveal how Lively coordinated her public response, who she consulted, what narratives were crafted behind the scenes. When you're fighting a legal battle that's as much about reputation as it is about facts, controlling which allies and advisors get exposed becomes critical. And that's exactly what this motion accomplishes. So here's the real question. Does this look like a principled stand or a carefully calculated legal strategy? If you think it's the second, Go ahead and like the video and subscribe. You'll want to see how this unfolds. Here's the part that should concern anyone who believes in transparent justice. Most people going through civil litigation don't get this kind of protection. If you're fighting a divorce, your financial records are public. Your custody disputes are public. Your personal communications, if they're relevant to the case, become part of the court file for anyone to read. There's no special carve-out for embarrassment or inconvenience. You're in court, and the same rules apply to everyone, except, apparently, when you're wealthy and famous. Then you can argue that your privacy interests outweigh the public's right to know what's happening in a case you chose to file. You can claim that transparency would create security risks or unfairly expose people who didn't ask to be involved, even when those people are central to the story you're telling. The legal standard for sealing documents is intentionally strict. Courts conduct a balancing test, weighing the public's right to access information against the private individual's right to keep certain details confidential. And critically, any redactions must be narrowly tailored. You can't just black out entire sections of evidence because it's uncomfortable or politically inconvenient. You have to prove that the specific information meets a high bar for privacy protection and that hiding it serves a legitimate purpose beyond avoiding embarrassment. Lively's motion doesn't meet that standard. It's heavy on conclusions, light on analysis. It asserts that certain information is private without explaining why. It claims security risks without demonstrating how those risks arise from the actual content in question. And it treats Ryan Reynolds, a man who was literally a co-plaintiff until recently, as though he's now an uninvolved bystander whose communications are suddenly off-limits. But here's where the story takes a sharper turn. Sony Pictures just filed its own motion to seal documents, and the language Sony uses is far more aggressive than anything we've seen before. This isn't a quiet request to protect a few email addresses. This is a studio publicly distancing itself from Lively's tactics and calling out what it sees as a deliberate misuse of evidence. Sony specifically objects to testimony from one of its employees that appeared in the defendant's summary judgment motion. The studio argues that this testimony was included not because it's relevant to any legal argument, but because it exists on the same page as other cited material. In other words, it got pulled in accidentally, and Sony wants it sealed because, according to their filing, the only reason to make it public would be to gratify private spite or promote public scandal. Let that phrase sink in. Gratify private spite or promote public scandal. That's not standard legal boilerplate. That's Sony accusing someone, in this case, of weaponizing court filings to embarrass and damage reputations rather than to seek justice. And while Sony doesn't name Lively directly in that passage, the implication is unmistakable. But Sony goes even further. The studio takes aim at Dr. Jennifer Freed, a psychologist Lively retained to provide expert testimony about institutional betrayal and psychological trauma. Freed submitted a lengthy report that Lively used in her opposition to the defendant's summary judgment motion. Sony claims that Freed selectively quoted an email from a Sony executive, lifting a single sentence to create what the studio calls an inflammatory impression while deliberately omitting the sentence that immediately followed, which would have changed the meaning entirely. Here's what makes that accusation so damaging. The underlying email that Freed quoted, the one that contains the missing context, was never included in the court filings. And the executive who wrote that email was never deposed, never questioned, never given the opportunity to explain what they actually meant. So you have an expert witness cherry-picking language, presenting it as evidence of corporate misconduct, and then moving on before anyone can examine whether the interpretation is accurate. That's not expert analysis. That's narrative construction. And Sony is now calling it out in writing, in a public court filing, for everyone to see. Think about what that means. Sony Pictures, a studio that has every incentive to stay neutral and avoid controversy, is risking public blowback to challenge how Lively's team is handling evidence. That suggests the misrepresentation was significant enough, blatant enough, that Sony felt it had no choice but to respond. This isn't a minor procedural dispute. This is a studio accusing Lively's expert of distorting facts to support a predetermined conclusion. And remember, this is the same expert whose entire report Lively submitted to the court. Sony isn't objecting to a footnote or a tangential detail. They're objecting to core testimony that Lively relied on to oppose summary judgment, the motion that could have ended significant portions of this case before trial. If that testimony is built on selectively edited quotes and missing context, it undermines the foundation of Lively's legal argument. Now, Connect this back to the sealing requests. Lively wants to hide communications with third parties, financial details, and messages involving Ryan Reynolds. Sony wants to seal employee testimony and emails that, according to the studio, have been taken out of context or presented in misleading ways. Both sides are trying to control what information reaches the public, but their motivations appear to be fundamentally different. Lively is trying to protect her image and limit exposure of behind-the-scenes coordination. Sony is trying to prevent what it sees as unfair characterization of its executives and employees, people who didn't choose to be part of this fight, and whose words are being weaponized without full context. Ask yourself this: if Lively's case is as strong as her initial complaint suggested, why is there such a desperate push to keep so much hidden? Why are we seeing motions to seal that go beyond standard privacy protections and venture into sealing entire categories of potentially relevant evidence? And why is Sony, a party that has remained relatively quiet until now, suddenly filing pointed objections that accuse Lively's team of misusing the judicial process? The answer might be simpler than it appears. Lawsuits like this aren't always about winning in court. They're about winning in the court of public opinion, about shaping the narrative so thoroughly that the actual legal outcome becomes almost secondary. If you can control what the public sees, you can control how the story gets told. And if you can keep unflattering evidence sealed, you can maintain the illusion that your version of events is the only version that matters. But courts weren't designed to be reputation management tools. They were designed to resolve disputes based on facts, evidence, and law. And when one party starts treating the judicial system like a public relations strategy, other parties notice, judges notice, and eventually, the cracks start to show. Sony's filing reveals those cracks. The studio's willingness to publicly challenge Lively's expert to accuse her team of selectively editing evidence, to use language like gratifying private spite. That's not the behavior of an institution trying to quietly settle a dispute. That's the behavior of an institution that believes the process is being abused and wants it on the record. And that brings us to the broader question. What happens when the rich and powerful use the legal system not to seek justice, but to control information? What happens when sealing motions become standard practice? When every uncomfortable email or revealing communication gets buried under claims of privacy or security? The answer is that the public loses access to the truth. Courts become private battlegrounds where only the participants know what's really happening, and accountability disappears. This case is testing those boundaries. Lively is pushing to see how much she can keep hidden while still maintaining the appearance of transparency. Sony is pushing back, demanding that the court recognize when evidence is being manipulated or misrepresented. And somewhere in the middle, the actual facts of what happened on that film set, the real story of who said what and who did what, are being obscured by legal maneuvering and strategic redactions. The outcome of these sealing motions will tell us a lot. If the court grants Lively's requests in full, it signals that celebrity and wealth do create different rules, that the transparency guaranteed by the First Amendment can be negotiated away if you have the right lawyers and the right arguments. If the court denies the requests or demands more specific justification, it reaffirms that public courts belong to the public, and that no one, regardless of fame or influence, gets to unilaterally decide what information the rest of us are allowed to see. But here's what we know right now, regardless of how the judge rules. Lively filed a lawsuit that accused powerful people of serious misconduct. She put that accusation into the public sphere, invited scrutiny, and demanded accountability. And now, when the evidence is being examined, when communications are being disclosed, when the other side is presenting its defense, she wants large portions of that process hidden from view. That's not how justice works. That's how reputation management works. And Sony's filings suggest that at least one major player in this case has had enough of the strategy. So where does this leave us? With a lawsuit that may never reach a jury, because the real battle isn't about legal liability. It's about narrative control. It's about who gets to tell the story and what parts of that story the public will ever see. And right now, Blake Lively is fighting harder to seal documents than she is to prove her claims in open court. That should tell you everything you need to know. Was this ever really about justice? Or was it always about reputation? Was this a genuine legal fight, or a calculated move to shift public perception while keeping the messiest details buried? I'll let you decide. Drop your thoughts in the comments below. And if you want to keep following this case as it develops, subscribe and hit the notification bell. There's a lot more coming, and it's only going to get more revealing from here.